which is out there. When you look at the list of functionaries, we find that they are the police, healthcare practitioners, social workers, teachers, anyone who works in the institution that involves children. Those are health. Those are the practitioners that they need to report it. But then, if you go through to section 2 with the capital letter B, they, well, that is an adult person also has got an obligation to report when they realize or when they know that, or when there are suspicions that this person is a victim of domestic violence. They have to report it. There is a form, if you go to the regulations, form 2, that they have to do it, complete it, and to report in that matter. Prosecutors are not mentioned here as functionaries, but we know that there are so many decided cases which says that prosecutors or court officials also have a duty to report when they come across, more especially when it comes to children, when they come across that a child is a child in need of care and protection. That we cannot turn a blind eye against that. Then the prosecutors have to report about that. Okay. The Act provides a person with a material interest being a victim of domestic violence to bring application. We know, as it is listed in the Act, who can apply for domestic violence. Who can apply for domestic violence? That means the victim can apply for protection order. Any person or the victim, or any person on behalf of the victim. That person, if that person has got an interest in the well-being of the victim. But if the victim is an adult, then that means the person need to get a consent from that person to apply for protection order. Not unless the victim is a child or the victim is someone who is mentally challenged. Then you don't need a consent. Or a victim is someone who's unconscious. You don't need a consent. Or else you can apply for protection order on behalf of someone when the court then would declare that person as a person who's unable to give consent. But prosecutors should avoid being involved in applications of protection orders because there might be a conflict of interest at the later stage where they have to prosecute in those cases. Okay. Prosecutors may refuse to institute. No prosecutor may refuse to institute a prosecution or withdraw of charges in respect of contravening of these protection orders. Yes, in fact, and in respect of any offense against a person in a domestic relationship. Bear in mind that when in a domestic relationship, it doesn't mean there must be a protection order, that you are in an affair with this person, then they should not withdraw those cases. When they go through the facts of the case, you see that these people are staying together, or you see these people are lovers, or you see that there is a domestic relationship between the two. So prosecutors are not allowed to withdraw those cases. And in respect of cases whereby there's in a domestic relationship, there's one of the victim has got sustained previous bodily harm. Those cases that the prosecutors are not allowed to withdraw. Where the complainant has been threatened with a weapon, also, those cases in coming out of a domestic relationship, they should be taken as a serious cases. Yeah, the people that it's only the Director of Public Prosecution, that the DPP of that certain region or province that can withdraw those cases, or else the people who are delegated to do those withdrawals, which would mean then in many instances, those are senior public prosecutors that would do those kind of withdrawals. After taking into consideration the following factors, they have to take the following factors into consideration: the history of violence between the parties, the period of abuse the seriousness of charges facing the accused person, whether the complainant is sharing a residence with the accused person, and whether the complainant will need alternative accommodation should the charges be withdrawn. The use of firearms or terrorist weapon that will be taken into consideration. The extent of injuries sustained by the victim should be taken into consideration. The existence of protection order or any violation of such protection order in the past. Also, that we need to take into consideration when we are deciding on the cases. The relevant previous convictions also should be taken into consideration. Yeah, when you say the relevant, then it doesn't mean that it should be the breach of protection order. If the breach of protection order was now is assault the person and he's got previous convictions of assault, then those are relevant in the circumstances. Yeah, the possibility of manipulation, coercion, intimidation, or pressure to request the withdrawal on the part of the complainant. Yeah, we know in many instances that people are coming to court to withdraw these cases. More especially if you have worked in the district courts, you will see once the complainant, what I've realized, once the complainant comes in with being with the company of people, and when you ask these people, who are these people, and these are my in-laws, you know that this one is there to withdraw the case. It's hardly you find cases when the in-laws are here to support to proceed with the case against their son. So we need to look at those cases that there might be a pressure on this one to withdraw, and we need to advise these people, because some they withdraw these cases because the fear is that this is a breadwinner, and then if the breadwinner is will be sentenced into jail, they will suffer. Not knowing that there are so many provisions when it comes to sentence. So it is our duty as well to advise them that no, if there should be a suspended sentence or there should be periodical imprisonment, all those kind of sentences. So we should not just let go just because this one requested so. Yeah. Where the withdrawal of a charge is at the request of complainant, the request must be in writing and filed in the docket. You'll understand that as prosecutors, we are the one who are domicilities. We are the one that are making decisions. It's a request from the complainant to withdraw the case. It's not that the complainant is withdrawing the case. The decision is upon us to withdraw these cases or not. We might refuse to withdraw the case, even if the person has filed up a withdrawal statement. Prosecutors should consider alternative restorative justice mechanism in appropriate circumstances. Yes, there are those cases where we look up and say that, okay, it's not maybe it was an exchange of words between the two. A couple, they need a kind of counseling. Then you refer them to all these institutions that will deal with psychosocial services to go and do the counseling and see and make things right. Okay. Where a warrant of arrest in terms of this section has been executed and get lost, destroyed, the prosecutor should refer the complainant to the clerk of the court to apply for a second or further warrant of arrest. Yes, yeah, when the warrant of arrest is lost, it doesn't mean that the complainant doesn't have anything is not protected at all. Look, there are instances whereby in some courts, we found out some of cases were not enrolled because there was no warrant of arrest. And then you look at it, you say that, but there was a commission of offense. there is a statement from the complainant to say that I was violated, even though the warrant of arrest, I've lost it, but now I was violated. It doesn't mean that the person should not be arrested. It doesn't mean that the person should not be prosecuted. Yeah, if you look at the, I think the state versus Lamini. No, Lamini versus the Minister of Safety and Security. It's 2016, Volume 2. Lamini versus Minister of Safety and Security. 2016, Volume 2, SACR 655. Even there, there was a warrant of arrest because the accused has committed the offense, and then there was no warrant of arrest. And further, there was a statement, A1 statement of the complainant, where he took it under oath. That's what even the judges said, that if there is an affidavit statement under oath to say that this person has committed this offense, you shouldn't rely on that affidavit of that person if there is no warrant, if the warrant of arrest has not been issued. Because when the presiding officers are issuing this interim protection order and the final protection order, they issue them with a suspended warrant. So if that suspended warrant is got lost, it doesn't mean that the person cannot be arrested. Okay. While we are still talking about the arrest and warrant, you will see that in the Principal Act, the one which is still in operation as for now, which they say that police, when they arrest a person, before they arrest, they should assess the situation. If they should arrest only when there is an imminent danger, the victim. If there is no imminent danger, they can give them a notice to appear in court. But when you look at this, Amendment Act, the Amendment Act doesn't speak of imminent danger or imminent harm. Doesn't speak of imminent harm, but it speaks that when the police can arrest, may arrest the complainant if he comes to the scene and found that the perpetrator is committing an offense which constitutes a domestic violence, then they can arrest. It doesn't speak of there is an imminent harm. And then it's when this police suspect of this person has committed this kind of an offense, because this imminent harm, the police should arrest only when there is imminent harm. This let's bring so much confusion to the police, because the discretion has been on the police to arrest it or not. Based it was subjective. Yeah, some they arrest, some they don't arrest. It depends how you support it. But now give the police to arrest only when there is an offense has been committed, and then there's an evidence that the offense has been committed. But this new act doesn't speak of imminent harm. General, prosecutors are not required to deal with appeals or reviews application against granting this protection order. Yes, but we in some instances come across with protection orders that were granted and then they were breached. Someone has been arrested. It comes to us. When you look at this protection orders, it's not really enforceable. You can't enforce it. It's an order, and it has been breached accordingly. But look, there are protection orders that I've come across with, whereby some of the protection order that I always mention is when by someone, the protection order was, don't greet all your colleagues and left the complainant and left the applicant. You know, now you've been arrested for not greeting this person. Can we enforce? Are we expected? Some of that don't gossip around about the complainant. You know, and some of the protection order says don't communicate with the complainant applicant in whatever way of communication. Then the second paragraph said, you must arrange with the complainant about this, transporting the child to school. Then this person WhatsApp the complainant, writing a message about the child, transporting the child, and then he has been arrested. So in those cases, like yesterday, we had a meeting with the judicial, where we said that these cases we need to take them straight to the chief magistrate to have a look at it and see what to do about those cases. Prosecutors must at all times take into consideration these comments which were made in this case, State versus Barnoy, 2000, Volume 2, SA 425, Constitutional Court. All crimes has harsh effects on society. What distinguishes domestic violence is its hidden, repetitive character and its measurable effects on our society, and in particular on family lives. It cuts across all races, class, culture, geographically, and it's all the more pernicious because it's so often concealed and so frequently goes unpunished. So at all times, we need to take all this into cognizance. Yeah. That's why at the beginning, I was saying that we as prosecutors, we don't get involved only when there is a breach of protection orders. Bail application, we do bail application. Yeah, we do bail applications, prosecutors. So going through this act, prosecutors should carefully consideration of should be given in question of bail. It has been shown that victims of domestic violence are more vulnerable to further and severe violence immediately after having made attempts to obtain assistance by conducting police or protection orders. We know that. Come again? Well, okay. We know for the fact that protection orders, they trigger anger. Protection.
Sorry, Khusi, let me just assist here. Please, will the people who have not muted, please mute your microphones. Thank you. Go ahead, Khusi, thanks.
Thank you. Protection orders, they provoke that anger. Every person, more especially, has been protection order. They tend to be angry. Look through have a look at the SIPS National Instructions on Domestic Violence. It says the police should not go alone in serving a protection order. You must go with your partners or as a backup. So we should know that also as prosecutors that these kind of things, they trigger this anger, and then we advise people. That's why we advise them also on their safety plan. Efforts must be therefore made to consult with the victims prior to the hearing and ensure that all relevant information is considered. You are allowed to consult with the complainant. You find that sometimes not everything is written on the statement, but to get a clear view of what happened when you consult with that person, then we are advisable that we should consult with the complainants, even when we're doing bail. Factors listed in C, which is previous serious charges, should be considered. Prosecutors must request police to inform the victims of the outcomes of bail application. If the bail is granted, the court must request to impose as conditions relating. The complainant should also be informed of the procedure to be followed if the accused person contravenes any bail conditions. Yes. Yeah, in areas where we have Pituzela care centers, the case manager who sits in court is the one that feeds the the Thuthuzela Care Center every day about the outcomes of the cases which were happening in court. If the bail has been granted and there are conditions, the case manager then inform the victim assistant officer at the Thuthuzela, and the victim assistant officer will be the one that will conduct the victim and say, the situation is like this. There has been granted protection order, and here are the conditions. Should the person breach these conditions, this is what we are supposed to do. So in areas where we don't have Thuthuzela care centers or case managers, then the police, prosecutors who are there must inform the investigating officers, even though the investigating officers know that what will be the outcome of the bail, but they must be also now and again be informed to go and inform the victim, because prosecutors should immediately cause some steps to be taken against any accused person who harasses, threatens, injures, or intimidates the victim or other witnesses of domestic violence. Yes, prosecutors and police are not allowed to set bail in matters that are domestic related. It must be the discretion of the magistrate to do that, so that they must do bail application, and then the decision should come from the bench. Yeah. And then there are these two cases that we need to take into consideration when we consider bail, or when we do this. The state of Minister of Safety and Security versus Michelle, this 2004 3 SA 305 SCA. Yeah, in this matter, the police and the prosecutor failed to put the relevant facts before court. Instead, they recommended that the accused be released on warning. Accused were released on warning. They should have foreseen the possibility of further violence crime being committed by the accused person. They should have taken reasonable steps to oppose bail to prevent his release. Due to the failure to execute their duties, negligence was established. That is why the state has to pay damages because of the negligence done by the prosecutor and the police in this matter. That is why then I say that the prosecutor and the police, in the matter of seriousness of the offense, which is domestic related, there's a domestic relationship, they are not supposed to grant bail or agree on that issues of bail. But when you look at this case as well, Minister of Justice and Constitutional Law 15. In this matter, the prosecutor failed to put all relevant facts before court in bail application. There was bail application, but he didn't put all the relevant facts before court. The results of this prosecutor's failure was that the accused who was charged for raping his daughter on 4 occasions, he was released because the prosecutor didn't put all the facts before court. Then it was held as to whether the prosecutor committed an act of delicti, that all forms of delictual liabilities were present. Wrongfulness, which is the first one, in that the prosecutor failed to take reasonable steps to prevent the accused released. Negligence, in that a reasonable person would have taken reasonable steps. Causation, in that the prosecutor would have prevented the harm that befell on X and the victim. So we should take into consideration all the time, because the issues of bail application is, we should not take them slight serious as a way of just doing it for the sake of doing it. These matters of gender-based violence are very, very serious. Trial processes. The prosecutor should consult properly with the victims and familiarize themselves with the court procedure. Where such services are available, prosecutors should make use of court preparation officers prior to consultation or thereafter consultation. But we must use the services of the court preparation officers. We must use the services of psychosocial services for assessments and all the stuff. Then it says, the directives regarding sexual offenses also apply with the necessary changes to domestic violence in matters like protective measures. What protective measures are we talking about? We're talking about Section 153 of the Criminal Procedure Act, where the testimony should be in camera. Section 154, prohibition of publication of the Criminal Procedure Act, which speaks of prohibition of publication of certain information relating to criminal proceedings. Section 11, subsection 2A of this Domestic Violence Amendment Act, which says no person may publish in any manner any information which might directly or indirectly reveal the identity of any party to the proceedings. Section 158, which the use of CCTV, and Section 170 with the capital letter A of the Criminal Procedure Act, which use the use of evidence through intermediaries. Then the last one, even though it's not here, Section 227 of the Criminal Procedure Act, which says that the sexual history of the complainant, no complainant should be. Sorry, I think my bad. No complainant Section 227 of the Criminal Procedure Act, which says that the complainant cannot be questioned about his sexual history or her sexual history in court. If one needs to do that, need to make an application first, and then give reasons why he do that, and then it's up to the court to allow him or not. But we should not allow people to do that. Going back to Section 170 with the capital letter A. In many instances, when you go to courts and you found that the procedure that they are doing in court is very light. When the victim, which is a child who's under the age of 18 years, then the prosecutors are supposed to make use of Section 170 with the capital letter A. So that the child will be assisted in testifying and testify to the CCTV. But now, the application that is normally done in this course is that the prosecutors will just say, Your Worship, I've got this witness who's 10 years old, and I'm invoking Section 170 with the capital letter, and then the magistrate allows that. Then, in this case, if you see, in this matter, the magistrate granted the application in terms of Section 170 with the capital letter on the basis that the witness or complainant is a child of 10 years. It was held that the youthfulness alone is not sufficient to grant this application. The court should consider the intelligence of the child, the IQ level, because everyone is unique, the age, the gender, the personality of the witness, and more. Yeah, those are the things that the court. So, which means clearly that before we go for trial with a child as complainant, child victim, as child witness, we need to refer them for assessment to the probation officers, and then we need to have that report. That report will also include, when they talk of intelligence, the age and gender personnel, it also includes the competency test, which would also make it things easy in court if we follow that route. Trial process, where the appropriate expert evidence regarding domestic violence on the victims and young children must be presented to the court. And we should all the time not forget the issue of victim impact statement.
No, we muted. No, we muted. We didn't like a. Oh, no, next. What?
Sorry, good afternoon, colleagues. It would seem that Advocate Khusi has been disconnected, or he's battling with his connection. We're just trying to get hold of him. So we shall let you know as soon as possible once we've been successful with that. We apologize for this little glitch in technology. We'll be back as soon as we can. Apologies again, colleagues. We're just waiting for Advocate Khusi to rejoin. He's left and he's rejoining the meeting. So hopefully he'll be with us in a second or two. Thanks. Hi, Khusi, are you back? Oh, good. Khusi, it looks like you're back. Whenever you're ready, you can continue. We can see your slides, although it's in not in presentation mode at the moment. If you wanted to change it to that, so the slides are slightly bigger if you can.
Can I proceed?
Yes, please go ahead.
Oh, okay. Thank you. Yeah. Sorry, guys. I don't know what happened. It just went like.
I think we're all experiencing a few, but maybe it's Friday afternoon. Maybe that's what it is. But please go ahead. Thanks, Kusi.
The victims should be informed about the outcomes of the trial in a manner enabling him or her to understand the reasons for judgment and, in the case, the conviction and the sentence. Yeah, we even after the trial, we need to inform the victims about the trial. Yeah. Okay. Now we talk of offenses which are coming out of this Amendment Act, because the Principal Act, you will see that the most offense which was there was the contravening of Section 17A, which is the breach of the protection order. Yeah, that was the main offense which was there. But now this new this Amendment Act come up with number of offenses. Yeah, this, although it's not in the act, but this is an offense on this one. Assault with intent to do previous with harm when people are in a domestic relationship, as we have said it before, that we consider also people who are in a domestic relationship, even though there is no protection order. Attempted murder, people who are in that category of domestic relationship. Murder in a domestic relationship affair. Then offenses which are in this Amendment Act is statutes contravening of Section 2A and 2B. 2A and 2B, the one that I've mentioned, that these are for obligation to report domestic violence and to provide information. So if the functionaries, as it says in Section 2A, failed to do that, or any adult person in terms of Section 2B failed to report when they know or when they suspect that, then the person can be charged and convicted. It's liable for conviction to a fine for a period not exceeding 3 months of both fine or imprisonment. Then we've got contravening of Section 5A, failure of the person who has been subpoenaed to attend to court or to give witness, or a specialist that has been asked to come and produce some certain documents, or any person who has been subpoenaed to come to court. If that person fails to come to court or remain in attendance until the person has been excused, then the person can be charged in terms of contravening Section 5A with 3. The penalty on that one, the person can be convicted to offense and referred to Section 3 and liable to a conviction to imprisonment for a period not exceeding 6 months, or both a fine or imprisonment. Then the 5A, we've got a 5B 11A. 5B 11A is a failure by electronic provider or any employee to furnish information. You know that this thing of the electronic communication service provider tool, whereby one has been abused through social media. Then if he goes to court and apply for protection order, the presiding officer has to give some directions to the service provider, to the relevant service provider, to supply the court with that information, and then to block or the link or whatever that information, so that it cannot be accessible by anyone. The service provider should provide with this kind of information within a period of a week, but they can ask for extension of another week if they want to do so. So they will have to apply a submission, and later they must inform the perpetrator that the court has asked for this information and we supply the court kind of thing. So to finish this court with the information that has been requested by the presiding officer, then that is an offense. Then in terms of contravening section 5B11A. Any electronic communication or employee of communication provider who is convicted of this can go to a fine not exceeding 10,000. An employee of the communication service providers, it could be a fine for a period not exceeding 6 months or a fine of such imprisonment. Then if you look at a 5B11B, the one that we have targeted is 5B11A. This 11B now, it makes of this amendment, making of false statement by electronic communication service provider. When the service, this service provider didn't give you the information you want, or make false statement in supplying the court with that information which was requested by the court, then also can be, if we found guilty, is a fine not exceeding 10,000, or of an employee of electronic service provider. Also, it's a fine or imprisonment not exceeding 6 months. When you look at 11C, we are still within section 5B11C. Failure by electronic communication service provider and employee to remove, because when the magistrate give them those directions, will say that remove or block, make it disabled so that no one can access that kind of information. If then one fails to do that as an electronic service provider, then the electronic service can be, if found guilty, then will be liable to pay a fine not exceeding 10,000, or an employee of that same to a period of 6 months, or to imprisonment or a fine. Then if we look at contravening of section 511D, BD, failure by electronic communication service provider or employee to inform the respondent, as I was saying that the respondent at the latest age need to be informed that the court asked for this information, and then we supply the court with that information. Then it could be a fine also of 10,000, not exceeding 10,000, or else the employee of that communication service provider to a fine, imprisonment, or for a period not exceeding 6 months, or both fine or imprisonment. Then we've got this offense, which is section 17A, which we know it's a breach of protection order, contravening the prohibition, condition, or obligation of protection orders. Yeah. Then if you are a first offender, you've been found guilty. First offender is to a fine, imprisonment not exceeding a term of imprisonment not exceeding 5 years. But if it's a second offender, then it's not exceeding 10 years. Section 17(1)B, prohibition of the publication of that information, which we said earlier on when we talk of protective measures, that the identity of the parties in the proceedings should not be published and all. Then if one goes through and then they found guilty, first offender to a fine for a period not exceeding 2 years, or to a fine or imprisonment. Second offender to a fine or imprisonment not exceeding 4 years, or both a fine or imprisonment. Then section 17, subsection 1C of this new amendment, the failure to comply with the directions of the court. The court might, if the media house asks for permission to publish the story, the court might give them directions or guidelines what they can publicize, what they cannot publicize. If the court allows them that you can publicize this and not the identity and all the stuff in a certain manner or in a certain fashion. Then if then one contravenes that, then he will be charged in terms of section 17, subsection 1C. In that case, if the person has been convicted, it will be a fine or imprisonment period not exceeding 2 years, or a fine or such imprisonment If it's a second offender, it's a fine, a conviction for a period of not exceeding 4 years, or both a fine or imprisonment. Okay, this one, contravening section 17(1)(d) of the Domestic Violence Amendment Act, making false affidavit regarding the contravention of protection orders. We know how much at times people, they manipulate the system. They come and then they make false allegations, contraventions of protection orders. Yeah, if it happened in that case, then the person, you know, sometimes we were, before this act, we're looking through the, charging this perjury and all. Yeah, but here now it says that the person can be charged contravening section 1D, 17(1)(d) of the Domestic Violence Amendment Act. And then the first offender is a fine or a period of imprisonment not exceeding 2 years, or both. Also, if it's a second, it's a fine not exceeding fine or imprisonment not exceeding a period of 4 years. Now, this one, when I'm closing, that the prosecutors, and when they are reading their cases and then first appearances, we do what we call trend analysis. We look at the trend of cases that we are receiving in terms of domestic violence, and where, in terms of the area where most of the cases are coming from, we red flag areas. Then that then becomes an indictment to us that we need to do intervention in certain areas. If then, even in sexual offenses, if it comes to a certain school, we are receiving so much cases from coming that, then this is an indictment that also, as PA prosecutors, we need to do awareness campaigns. We need to do some interventions going to those kind of areas. Also, we need to do multidisciplinary training to train people, our stakeholders, on matters of gender-based violence and the relevant legislation. That is all. Thank you.
Thank you so much, Kusi. That's fantastic. Thank you very much for your presentation. I know that we've had a couple of glitches. So just right now, what I'm going to recommend is that everyone place their emails in the chat, and Luando is also going to place his email in the chat, who is the administrator of all of these webinars and does a fantastic job of getting all of these presentations to people who do participate. So Luando, when you have a second, could you just place your email in the chat for people to email you, and or he will be emailing people who've placed their emails into the chat. Yeah, we clearly seem to have had just a little bit of technical problem. I'm not going to put my camera on now because I don't want to mess around with bandwidth. But what I am going to do now, because we do have a bit of time, is I'm going to open it for any questions or comments that people would like to direct to Advocate Kusi. Yeah, also just any comments, because I think that generally there is a slight misconception that the NPA is really very peripherally involved in domestic violence matters when it comes to the Domestic Violence Act. You know, short of obviously dealing with criminal charges that may accompany a protection order process, and then at a later stage if there are breaches of the protection order. But obviously, as you've heard from Advocate Kusi, there are many, many times other areas in which the NPA is involved, and the NPA has made it their business to be very supportive in the process, together with the Department of Justice, at making sure that this act does provide the proper protection. So I'm going to open it up. There were a couple of comments which I saw right at the beginning of the presentation, which I did take note of. So I'm not sure if the person who made the comment, unfortunately, I think it's Mbobi, Leo Mbobi. I may be pronouncing your name incorrectly, but there were a couple of comments around that you made in terms of advisability of prosecutors in terms of withdrawing cases, but actually to connect with DSD and other institutions that provide that kind of support, because we know very well why very many complainants do, or applicants do, want to withdraw their protection orders and or at a later stage any criminal offences. If you would like to address that, is it possible? I don't know if you're still in the meeting. Sorry, I made my comment earlier in relation to protection rights as well. Okay, your mic is not working. Thank you very much. Okay, I'll just quickly read it then, if you don't mind. And Kusi, maybe if you don't mind commenting on it. So the comment came from, I don't think it is advisable for prosecutors to withdraw cases based on their interaction with survivors, but for the prosecutor to refer the case to DSD and or any other institution that offers psychosocial support. And then further said that we further need to advocate for psychosocial supports to be offered in each and every court. So VEP social workers need to be in place in our court, basically the model that is being used by Mosaic in the Western Cape. And then again, another comment is obviously a concern that I think a lot of people have, and this is I think a general comment around how does a protection order protect women who are victims while the local chief in a particular area is chasing his wife with an axe when she has a protection order in her handbag. I think those are the realities which face a lot of people in the courts, whether it's clerks and magistrates and prosecutors who are dealing with enforceability of protection orders. Kusi, if you would like to comment on what was raised, and then again, just to remind anyone, if you would like to ask a question or make a comment, please just raise your hand, and I'll hopefully be able to see it and get you to speak and direct those questions at Advocate Kusi. Go ahead, Kusi.
Yes, indeed, there are complainants that are coming to withdraw the cases. That is why I've said earlier on that prosecutors are not allowed to withdraw those cases. Only the senior prosecutors are allowed to, the DPP of the area and the senior prosecutors that are mandated to do that. Then even them, they have to go through all those elements that I've put, the seriousness of the offense, the history of the offense, the history of the violence between these parties. And if that exists, they are not supposed, if the person has sustained injuries and all the stuff, they're not supposed to withdraw those cases. But in cases whereby there's no one sustained injuries, but it was an exchange of words between the parties and all the stuff on intimidation of some sort, then it's when those cases we divert them, we refer them to social development and to other areas of farms for psychosocial services. That is happening. That is happening. The hardest part of it is when we refuse your request, we decline your request to withdraw the case, and then the complainant just march out of the court and say that then I'm not gonna be part of this. She's the complainant who applied for protection order. Then she was victimized. She went to court, to the police and opened up a case. But during trial, she said, I don't want to proceed. And then we said, no, we're not withdrawing. And then she marched out of the court and said that I'm not part of this. Yeah, we are facing challenges of some sort. Yeah, and then in those cases which are very serious, we don't withdraw them, or we're not supposed to withdraw them. But those cases that you see, no, they need just counseling, then we do refer them. We do refer them. Yeah, but in the case where there's a local chief chasing the wife with a spade, we also, as NPA, have a project, which is Ndabezita project, whereby we trained traditional leaders on issues of gender-based violence, more especially on issues of domestic violence. Maybe that person, if he can drop me an email, not even mentioning the name of the person, just mentioning the area, so that we will know that when next time when we apply, we plan our things, we should cover that area. That's it. You know.
Thanks, Chrissy. Sorry, I lost you right at the end there. I'm hoping that everybody else was able to hear you. But thank you very much for your response. I think it is very often misunderstood or, sorry? Sorry, can I just get an indication from any other participants if you can hear us, or if it's my problem, or if it's with Husi? Luando, can you maybe just let us know if you can hear us?
I'm
Yes,
struggling
I'm able to hear you, but
the
connection is
also
very
struggling to
bad.
hear. The connection is really, really bad.
Yeah, I think that the connection is very bad on this
Yeah.
call for some other reason for everyone.
yeah, I've come to think about it. It's not only
Yes.
him though. I think it's the whole town. I'm not sure if you're around Pretoria. I don't know.
Can you please come again? I didn't. If I'm around Pretoria? It just went quiet now. Can you hear me, guys?
We can't hear anything at all anymore.
I can't hear clearly. Sometimes we hear and then it breaks.
Yeah. You were saying if I'm around Pretoria?
I was saying, Advocate, we're really struggling in terms of signal. I'm not sure whether it's something that is happening only here in Pretoria or what, because I can barely make sense of what you're saying. I'm not sure other people can actually hear you clearly. I don't know. It's just
Okay.
No, this is Connie in Northern Cape. I'm also struggling to hear what you are actually saying, Advocate. The connection is really bad. Thank you.
Heidelberg as well, Gauteng, the connection is very bad. I barely hear any sentence that you are putting forth. Thank you.
Okay, it looks like we're having trouble everywhere, Husi, unfortunately, with your connection. Do you want to try one more time, and then we might have to unfortunately wrap it up on the basis that we're just not really winning with connections. Could you just try one more time? Oh, okay. Advocate Kambula is saying it's a national problem. We might have to repeat this. Okay, I think maybe that is where we're going. Husi, we can't hear you. Hey, is that we've lost you?
Okay.
All right, it looks like it's going to be, yeah, it looks like everyone's having a problem. Husi, I don't necessarily think it's from you. I think it's everywhere.
It's everywhere, it's national.
Yeah, it looks like it's national everywhere, because it's strange that, I mean, I haven't had any problems all week, and I don't think anyone else has, and suddenly it's happening. So Luando, can I just get a little bit of direction from you? Would it be in order for us to close the meeting, and just to remind everyone to either put their email address into the email chat, into the chat box, or to email you directly. And if I could just read out Luando's email address for those of you who didn't see it in the chat. It's LDIKWENI@justice.gov.za. So it's L for Luando, and then his surname, dikweni@justice.gov.za. I don't know whether Advocate Kambula is back in the room. If I just need some bit of direction, I don't want to unilaterally close the meeting without just a little bit of direction from there. Okay, I think we're going to have to close it up. Okay, so if people can hear me, I'd just like to extend a very big thank you to Advocate Husi from the National Prosecuting Authority, from the Sexual Offences and Community Affairs Unit, for an incredibly comprehensive and detailed and helpful presentation. Thank you so much. I'm sorry we didn't have time to really engage with you further to draw on your expertise. And then again, to acknowledge and thank the Department of Justice for running and hosting these webinars under the leadership of Advocate Kula. Thank you very much again from Pillar 3. And also to Luando for doing all the excellent administration around these webinars. For those of you who've participated in a number of them, you'll be seeing that we're getting lots of emails from everyone from the department with copies of the presentations, which is really extraordinarily valuable and can also be used, I think, extensively in us rolling out these kind of trainings in our various sectors. So thank you very much again. And it's Friday, so I'm wishing you all a very good and peaceful and restful weekend. I hope no one's going to make you work too hard over the weekend. And really wishing you a safe, if you're traveling, a safe Friday afternoon traveling home, and to take care over the weekend. If there's anything, Luando, is there anything else that I need to mention from your side, from the department side?
No, we thank everyone. We thank everyone for participating, for being here. If we will try to rearrange, and
okay, that's great.
Sorry,
thank you so
sorry.
much,
Before
guys.
we close, through you, Chair.
Yes, go
I
ahead.
see. I'm trying to put in my email address, but it says that I'm no longer a participant, so I'm unable to jot down in the chat box my email details. Is there a way that I can send through my email?
Yes, I think the most effective way then I think would be to please email Luando directly. And his email is in the chat box. I'll read it out again. It's L for Luando and then his surname, DIKWENI @justice.gov.za. Is that in order?
It's in order,
Yes.
ma'am. Thank you.
Great, thank you very much. I'm sorry about this, everyone. Clearly, we've got some gremlins in our system today. Maybe we've all been working a bit over time, and so have the Teams app. So again, thank you very much for joining us. Thank you very much, Advocate Khusi, for your presentation. Wishing you all a peaceful and good weekend.
Thank you so
Goodbye.
much. Thank you so much, guys. Have a lovely weekend.
Same to you. Goodbye.